calling to order the January 8th Liquor Board meeting for the 11 o'clock docket. This is January 8th, 2015.
All right, good morning, everybody. Call the first case.
Chandra Vishwakama and Vishwakama Group, Medfield Mini Mart. This is at 4300 Falls Road, a Class A beer wine liquor license, application for transfer of ownership.
He is en route.
All right, call the next case.
Okay. Mi Young Oh Kim, Kimish Enterprises, Inc., trade name 57 Liquors. This is at 1300-02 Lawrence Street. This is a Class BD7 beer wine liquor, application for transfer of ownership.
For the record, Melvin J. Knensky, 19 East Fayette Street, representing the applicant. I'm standing in for David Wu, who is out of the country.
You gonna ask for any testimony?
I'm just going to submit some, we met with the Sandtown community, like, from Sandtown, we have a letter of approval.
You gonna ask question?
No.
Go ahead.
At this point here, we submit on behalf of the applicant, the letter from the Sandtown Community Group, who Ms. Kim has met with. They are satisfied with her. She's working with the community. She joined the community. She's been there working with them since October. And I think she's otherwise qualified. We asked the board to approve her, unless the lady from Sandtown would like to say anything. I don't think you're okay? Okay,
Anything else?
that's it.
Questions, commissioners?
What do you mean she joined the community? What does that
Community organization, she's been active in the community since she's been there in October.
mean? Oh,
Any other questions? None?
Is this the old wagon wheel? No?
Club Paradise.
Club Paradise.
That's it.
One second, your name?
Go to this thing.
What was it? I can't hear you. Shirley, speak up. P-A-Y-N-E. Your name, sir?
Larry Sink, S-I-N-K.
All right, swear the witnesses.
Raise your right hands, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Tried to get away. You confirm your testimony previously given, folks? All right, and the rest of you? All right. Any other questions, commissioners? Hearing none, time for decision. I vote yes.
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 You have our decision.
The first case is here now. Okay.
All right, call that case.
Yep.
Mr. Caduce, you can stand here.
Yeah, we just got to see right here. Yeah, it's over here.
Yes.
Call the case.
Chandra Vishwakama.
Yes, ma'am.
And Vishwakama Group LLC. This is the Medfield Mini Mart
Yes, ma'am.
at 4300 Falls Road, Class A beer wine liquor, application for transfer of ownership.
For the record, Melvin J. Knensky, 19 East Fayette Street, representing the applicant. This application is just a beer and wine license. It's a mini mart. He has met with the Medfield Community Association. He has a letter here of approval, subject to, which he agrees to. He will refrain, and I'll just paraphrase if I can, from selling beer cans as well as 40s, and he understands this will be part of the approval process. We submit this as exhibit number 1.
Exhibit one. Go ahead.
Other than that, he has been working with the community. It's a mini mart. It's a a little convenience store with a beer and wine license. Has been there for a while,
Yes, you have.
and he's the community is satisfied with him.
Any questions, commissioners?
I do have questions. According to our notes, this place was last inspected on December 19, 2013, and found operating. Is the mini mart still operating?
Mini mart is operating, but I don't know if they're using a license or not.
When-
Ms. Trigger is the one that owned the license.
When was the license last used?
I think I know because we don't represent the seller.
What evidence is there that the license is still valid?
You have to ask the executive secretary. I don't know.
It was renewed on time on March 28th. And they did show that they were operating, but we just hadn't had an inspector go there, I guess, since that period of time. So that's the reason why I put the last inspection date that we had on file. But they did renew normally.
What evidence do we have that they were operating and that the license was in use?
Only the fact that they did renew it and filed all their paperwork correctly for the 2014 renewal period.
That brings me to the point that we just discussed, and that is, we're going to have a new regulation that I'm going to propose, that licensees on both sides of transfers must be present at hearings. And this is, you see, this is the problem we're getting right now. We only have one of the licensees.
We have the buyer, not
We
the
don't have
seller.
it yet. It's a regulation, so, yeah. But we will, in the future, require both sides to be present.
Oh, I understand that, because a lot of times I never talk to the sellers at all, other than,
Not criticizing,
Okay.
I'm just pointing it out. That's the problem. But is it enough for us to stop, or can we go forward?
I think the first rule for any transfer is the license valid, whether it's a transfer of ownership or transfer of location. And if we don't have it, I'm not comfortable going forward. I want some evidence that the license is valid, that it has been in use, that the 180-day period has not run out without it being used. It probably is being used, but
well, all I know is
we
that
need evidence.
it's valid from the point that she paid for this year. You're questioning about the use of it.
Well, I think it's pretty clear that paying for it is not enough. We
Oh,
need to,
we could-
and we
I
can
know.
argue about
No,
that.
no,
It's
no,
a new
not today,
year.
though.
I don't want to argue
No.
with you the first bat, to bat with you in 2015.
That doesn't mean you're holding something back on me, okay?
Well, it's a long day. We'll wait and
So
see.
you-
But I'm
you-
glad to see you. But I do need, I personally need more.
Other than the use, could we say he's otherwise qualified with the Medfield? Only question you have is you need to know when it was last used. Would that be fair?
There's nothing that suggests he's not qualified.
Okay.
And it's helpful that Medfield is supportive, and I think that their letter clearly suggests that they're supportive. But it is of no moment if the license is not
No.
valid.
Other than I'll try to get something from Miss Joyce Trigger, is that the
Correct.
name?
And I was going to say that when we look at our, and I hate to say this, but when we look at the past inspections, the location was inspected probably twice a year and not on normal 4 times a year, even when we had regular inspectors. So so that might be, because it's probably it's an A license, so most of the time they're very reasonable.
A beer and wine, yes, that's on a lower scale.
All
Well,
right, then, we're ready for this decision. I vote yes on condition that that our commissioners' problems are complied with, that there is a valid license in operation at the time that this hearing is being held. That, if true, would be sufficient to okay the transfer. I don't think we have to have another hearing, so I vote yes.
too, vote yes, that the license is a valid license as determined by the administrative office staff.
So my instinct was to vote no pending receipt of evidence that the license is valuable. But to make it less complicated, so that it's clear, I'll vote yes on the condition that we are provided evidence that the license is valid and has been in use and has not expired through lack of use or for some other reason.
And that's what all three of us have said.
Yeah, and just making it clear that it's all three of us and
All right, you have our decision.
all right, fine, thank you.
Call the next case.
Christopher Bennett, Carrie McIntyre, Kathleen Williams, Interstate Management Group, LLC, trade name Hyatt Place. This is at 511 South Central Avenue. This is a Class BHM, beer, wine, and liquor for a hotel motel. This is under application under provision Article 2B, 6-201, D2, requiring a minimum of no less than 100 rooms, a dining room with facilities for preparing and serving meals, and at least 125 people seated, and a capital investment of $500,000. Application also includes a request for live entertainment and outdoor seating.
All right, counsel, enter your turn.
Good morning, Your Honor, members of the board. For the record, my name is Linda Carter, and I'm here this morning.
Talk a little more clearly so we can hear.
I apologize. Good morning, Your Honor. My name is Linda Carter, and I'm here on behalf of Hyatt Place.
All right, we'd be glad to hear from you. Do you have testimony?
Thank you. We, only if the board desires it after I make some proffers, if I could, sir.
Well, not knowing the answer, swear the witnesses.
Raise your right hands, please. Will you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Thank you, sir. With me today, I have the three licensees and the three applicants to become licensees, and John Parker, who is right now the resident manager, and I say that because he's spending at least 80 hours a week on this property. The hotel, which opened on December 11th, cost about $26 million to build and furnish, so I think we meet the $500,000 requirement of capital expenditure. It has 208 rooms and can easily feed at one seating in excess of 250 people.
It meets the requirement.
Yes, sir. Yes, sir. The hotel is I really hate to say limited service hotel because it's not a full service hotel in the hotel definition, but it certainly is a hotel of which the city will certainly be proud. Each room has a 42-inch HD television, has Wi-Fi hookup, has safes, a mini refrigerator, coffee pot, granite top counters in the bathrooms. There are handicapped accessible bathrooms. There are bedrooms of different sizes, from suites to a single standard room. All of the rooms have a sit-in area and a desk with phones that have both speaker and hands-free sets so that it's business friendly. There is a complimentary breakfast available daily. The 24/7 gallery is exactly that. It is open for eating 24/7. However, John has made the decision that alcohol will only be available from 12 to 12 noon till 12 midnight. Yes, sir, and throughout the hotel. There are no mini bars in the rooms. There is no standardized room service, but if somebody called and requested a bottle of wine be brought up to their room, John would arrange for one of his certified staff to do that. Hyatt has a very intensive training program for its employees, and I think you said 18 employees are going to be involved in the sale of alcohol, and all 18 will in fact go through the Hyatt training program.
You have a request for live entertainment and outdoor table service.
Outdoor table service we'd like to eliminate because we thought at the time we were going to be able to do it. We can't do that. Live entertainment would be.
So you want to withdraw that?
Exactly, if we could. Live entertainment would be requested only if somebody is using one of the banquet or conference rooms for a small wedding, a bar mitzvah, a birthday party, retirement party. They might bring entertainment in. The hotel itself will not offer live entertainment, ever.
So what are you talking about?
There are banquet facilities within the hotel, and so if I have a birthday party, I could bring in a band for the birthday party. But the hotel, in its restaurant and dining areas and its lounges, will not have any live entertainment.
What's the capacity of the largest room they have there?
Guest room or meeting room?
Meeting room, 250?
2,600 square feet total, and we can easily house over 225 people in there.
So if I want to have a party there with a band, that would be okay?
That's what we're asking for.
Yes.
Yes, I'm sorry.
Any other questions, commissioners? I
What-
assume there's no opposition here.
Not that we're aware of, sir.
What would be the capital investment excluding the building, because we can't count the building? Just for the interior space.
I would imagine it's in excess of $5 million. It's well in excess of $500,000. We have that just in the TVs.
Oh, really? Wow, okay.
Any other questions?
Was that the 42 inch or 45?
42 HDs.
And the remote controls will always have the batteries.
In them, working batteries. Is that going to be a condition on the license, madam? Believe me, I understand.
And the lamps, right?
Yeah,
Absolutely.
and bulbs in the lamps that work, not just bulbs, but they work.
Anything else you wish to say?
No, sir, we would request that the exhibit book that I gave you all, did I give you one? I apologize. Be introduced as applicant's exhibit number 1 and be
Okay,
made part of the
mark it as
record.
number 1.
And on that, Mr. Chairman, we would rest.
No other questions? The time has come for decision. Vote yes.
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 You have a decision.
Thank you much. You all have a pleasant day and a fabulous new year.
All right, thank you. And there's some little, some business that needs to be taken care of down to the right.
Right, you mark, push this.
Okay. It's from the chairman.
Call the next case.
Randall Garuti, Jeffrey Utt, Harvey Goldberg, Shake Shack, Pratt Street, Baltimore, LLC, trade name Shake Shack, that's at 400 East Pratt Street, a Class B beer wine liquor. This is an application under Class B, under provision 2B, 6-201, requiring $700,000 in capital investment in restaurant fixtures and a seating capacity not to exceed. This is actually 75, not 150 as
It
is.
should be, it's under 6201D1.
Yeah,
So
this-
it should be a $500,000 capital investment.
Correct, this is the incorrect way this is written, so what we need to do is, this is under the $500,000 in capital investment and 75 people versus what's, printed in the, and staff has changed that in the application process.
Enter your appearance, please.
And it's also a request for outdoor seating.
Sir, thank you. Good afternoon. Leanne Schrecken Goss, Royston, Muller, McLean, and Reed, here on behalf of the applicants.
You're going to have any live testimony?
I'm going to proffer.
Go ahead. We're glad to hear from you.
As indicated, this is an application for a new restaurant. It's a fine casual burger joint that's going in at 400 East Pratt Street. As we indicated, there's a $500,000 capital investment requirement. You should have the capital investment breakdown in your files. $543,000 has been spent to date, with a total of $1.3 million going into the entire building. The seating capacity is 124 plus additional 20 seats on the exterior. And we are obviously required to meet the 49-51% food to alcohol ratio. Shake Shack trends at literally only 3% alcohol sales. You should have all the background checks from the applicants indicating that they are all fit and proper individuals. And there are also letters in support from both the Downtown Partnership and the Waterfront Partnership with respect to this establishment.
Is there any opposition that you know of? Questions of commissioners?
Just to clarify, how do you differ from McDonald's and Burger King in terms of fast food versus fine casual dining?
Can we go ahead and swear in the witnesses?
Yes, I thought we did that. No.
Raise your right hand, please. Do you swear or affirm the testimony you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Please identify yourself.
I'm Randy Garuti, the CEO of Shake Shack and one of the owners, and I've been working with our company 15 years. We have a 30-year history of running New York City's favorite fine dining restaurants. That's our history. We opened Shake Shack as a community venture in a park 14 years ago as an accident, and it became what it became. So we've always used fine dining ethos. Chefs, our culinary director is from a 4-star restaurant in New York City, and we use all natural, no hormones, no antibiotic proteins. We cook everything to order. It is not fast food. Never been accused of that. If you wait online, you'll know it's not too fast. And we've always had great beer selection, great wine selection. But as mentioned, it's a very small, 3 to 5% of our sales. So it's a small part of our business. We're really about frozen custard. We're going to work with some local Baltimore bakeries to do some cool cookies and mix-ins that we put into our frozen custard, which is our ice cream. And we do everything to order, and with a fine dining mentality. So we've been called fine casual. Sort of the anti-chain chain is what has been written about us.
So my question was prompted by an article in the Baltimore Business Journal that referred to you sort of, kind of,
Sure.
as fast food, and licenses cannot be given to a fast food restaurant. So I wanted to get clarity on what it is that you are. I guess I could have called my daughter in Brooklyn and asked her, but
She'd probably be the best one.
yeah.
Yeah, I mean, I don't think people would call us fast food. So that, we saw the article, I don't think it's, yeah, you can look at the pricing as well. We don't do combo meals. We don't do the kind of fast food traditional thing.
So you're not serving food in a bag and I can't
Well,
drive-
you
I
may
mean,
take
I
over
can't
the
pull up
way,
to a
sure.
drive-in
There's no such thing as a
window and-
drive-through, no.
They
Okay.
actually have a host that greets you when you come in, hands you a paper menu, answers questions about the menu. And then they have what they call a hospitality champ, who will help you find a table, assist you with getting refills, condiments, and all that kind of stuff, which is something you're not gonna find in.
And after you order, you actually get a buzzer, you go sit down, you wait, because we're cooking your food to order, we're not cooking it, it's not pre-cooked sitting there. So it's totally
That alone
different
means
thing.
it's not fast.
Indeed.
Okay, that's all I needed, thank you.
All right, no other questions? The time has come for a decision. I vote yes.
Wait, I did have another question.
Oh, go ahead.
I apologize. So, on the application, it looked like the three folks on the license, no one has a financial interest, but it was Randall Garudi, is that?
I do have a
financial
interest
In the parent
the
company.
parent company.
You're Randall, right?
I am, yes.
Okay,
Sorry, I
so-
said Randy.
And then Jeffrey Utz, is that you?
Yes, correct.
Okay, so you guys do have financial interest
Yes.
very much. You're one of the owners, right?
Yeah, I have a financial interest as well.
And you're
Yeah,
one of the owners?
Indeed, yeah.
Okay. All right.
They don't have a direct ownership in the licensed entity, that's why we answered no to that question. It's to the parent company.
The licensed entity is a wholly owned subsidiary of the entity that we have the financial interest in.
Well, who owns the, so it's Shake Shack, 400 East Pratt Street, who owns that?
Shake Shack Enterprises LLC is the 100% owner of the licensed entity.
Okay. Right, I got it.
Yes, it's looking at this, dollar amount, forecast total, $851,810, actual, $294,805. I'm assuming that the $294,805 is what you actually spent to this point.
That's correct.
All right.
The
So the
numbers in the
forecast is,
Far left column.
right, so I'm assuming that also that, when you get finished and your bottom amount is gonna be at least $851,810.
1.3 million.
So, okay.
Yeah.
So you
That's
usually
just-
go
yeah.
up and not come down.
Exactly. If you add this 800 with the rest of the column underneath it, which is furniture, fixtures, and equipment, it puts us at 1.3 million. And so the furniture, fixtures, equipment, computers alone meet the $500,000 requirement.
Anything else? Vote yes.
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 You have our decision.
Thank you all very much. Happy New Year.
Happy New Year.
And the exhibits
One,
one
two,
collectively.
all right, collectively,
I'll call the next case.
Yes, sir. Make sure. One
This
second.
next one is postponed, I have.
Yes, sir. The next one is postponed, so it's Siam Polturi, Rakanish Pingili, Joseph Liberici, VD and SR Pharmacy LLC. This is Park Avenue Pharmacy, located at 1535 Park Avenue, a Class A beer, wine, liquor license, and application for transfer of ownership.
Morning, for the record, Alfred L. Brennan Jr. You have a card, sir?
Wait a minute, I don't have that.
This Park Avenue, right?
so just so for clarity, 1800 Thames Street was postponed?
Yes,
That was Penny Black,
Yes.
Baltimore Inc., trading as John Stephen. That's
Yes.
postponed.
yes.
So now we're at 1535 Park Avenue, right? So, does that help?
I don't have it.
No, he doesn't have it. I'll give it to him right now.
Here. Here's mine.
I don't know why.
That's strange, right? Normally it's me.
I think you got Harvey's packet.
I don't know. Did you get that?
Yes, I have it, yeah.
All right, call the case. Have you called it?
Yes, I have, sir.
All right, who's,
For the record, Alfred L. Brennan Jr. for the applicants,
you gonna have any live testimony?
only if the board requires it.
Glad to hear from you, sir.
We have approval from the Mount Royal Improvement Association. Stephen Howard, the chair, is standing to my left. I'd like to introduce the letter from that. You're the secretary? Okay, the secretary. Also, we have a letter from Bolton Square Homeowners Association approving the transfer. Also have a letter from J.M. Flanagan Antiques. He owns a business in the area, approving the transfer. A letter from Janice McCauley. She owns Bell Hardware. She's approving the transfer. There's also a letter from Bolton Hill Bistro approving the transfer.
Anybody opposed to it? You want to collectively introduce all of them?
I will.
All right, we'll collectively put all these letters in as Exhibit 1. And they speak for themselves. Commissioners, you can go through. All right, and no opposition. All right, and no testimony. Anything else you wish to say?
That's all.
Questions of commissioners?
Um, So this license is currently in operation. It's not lapsed in
There's a
any way.
licensee right there.
Oh, you're the current licensee. Oh, sorry. We need to have you.
Yeah,
Did
one
you,
at a time can speak.
were they sworn?
No.
All right.
Raise your right hands, please. Do you swear or affirm the testimony you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth? And please state your name, come to the microphone, and state your name.
Joseph Labercy, I'm the current liquor licensee.
Joseph
Labercy,
Spell.
Libercci. And I,
Okay, so the license is in use
Oh, yeah.
and has been in consistent, constant use
32 years, yeah.
for 32 years. Okay, all right. It's pretty strong evidence. All right, that's the only question you have?
All right, no other questions?
None.
All right, I vote yes.
Yes.
Yes. What is this?
You have our decision, sir. Unanimous.
I found it behind this.
Do you have yours?
That was mine.
All right,
Mark this
I gave
as
mine to,
collectively as part of that.
Okay,
yeah, I don't need it.
okay, thanks.
Judge has it.
Okay. 2 seconds, Judge, and I'll be right.
Got a lot of paper floating around, so this is
Look
exhibit
at us.
one.
Yeah.
Collectively exhibit.
Yep, I'm bringing it all together, and I'm banding it up. All right, sir, I will read the next item, which is a hardship extension for William Brzezinski and Scott Backetter and Maria Brzezinski, BPM Restaurant Group, LLC. This is at, trade name is Mr. Rain's Funhouse, 800 Key Highway, a Class B, beer, wine, and liquor, a request for hardship extension under provision of Article 2B, 10504D.
For the record, Melvin J. Kadensky, 19 East Fayette Street, requesting on behalf of the landlord here a hardship extension. The particular location is at the American Visionary Art Museum on the 3rd floor. The prior tenant and licensee had stopped doing business on June the 14th. We requested a hardship extension on November the 26th. At this time, we have an application just filed pending, but due to the fact that we're not sure if it'll go through, they're requesting the hardship in the event that the new applicant is not approved, they would have time to go ahead and transfer the license to a new tenant.
All right, questions, commissioners?
So they stopped operating June 14, and the application for hardship was filed.
November 26th,
Yeah. November 26th is the
So
meeting.
he's the
Okay.
first period, you see, he gets.
First
And then-
100
And then
days.
he
And you-
asked for his additional time.
Okay.
He's okay. Any other
All right.
questions?
No. Just some confusion. So you're saying this is on the first floor of the?
Third floor.
Third floor, okay. Now I'm no longer confused. I'm like, I'm drunk on the third floor, but not on the first floor. Okay. All right. Third floor.
Anything else?
No.
Yes. Yes.
Yes.
All right,
You have
thank
our
you.
decision.
Thank you very much.
Commission meeting. This is the 1 o'clock docket for violations.
Call the first case.
The first case is Alexandra Abreu, Maria Hernandez, El Estanco LLC, El Estanco at 45 North Crescent Street. This is a Class D beer, wine, and liquor, and a violation of 405 for prohibitive hours on November 2nd, 2014. Officers observed an establishment open. There's a second violation of Rule 418 for November 2nd, 2014. Again, at 2:11 in the a.m., officers observed people within restricted hours, and the period of the establishment was supposed to be closed as 1 a.m.
Call your case.
Thomas Hackers on behalf of Liquor Board, Your Honor. Your Honor, in this case with El Estanco, I spoke to the attorney, Paul Schuman. He is actually on his way. I spoke with the licensee outside. She said that he was parking in transit. So because there's counsel in this case, I'm just going to ask that this case be held, and we can address the Max's Charles Village case first.
Sure.
Only because I know the attorney's on his way, and I spoke with him earlier.
Okay, good.
If I may call the next case.
Call the next case.
Liquor Board versus Max's Charles Village LLC, Robert Kern and Joyce Chung, trading as Max's Pizza Bar and Grill.
Good afternoon, Mr. Chairman. For the record, Frank Boozer on behalf of Max's Charles Village LLC, both licensees present to my right.
All right, you're going to have live testimony?
Your Honor,
Yes.
all my witnesses are present today, Your Honor. They're all actually filing in right now. So I'm just going to have a moment until they all come up, Your Honor. Your Honor, we're going to be going forward on all counts today. This is going to be an agreed statement of facts, and I can read it from the record right here, Your Honor, if you'd like, and I have evidence to submit.
Do we have an agreement all the way through on this case?
We have an agreement all the way through, and if you'd like, I can advise the board as to the agreement we're presenting to the board.
Yes.
It is going to be a 6-week suspension, Your Honor, starting today,
That's correct.
and it will be a $8,000 fine. It'll be $3,000 for the first count, violation of cooperation, $1,000 for the second count, $1,000 for the third count, both of these are minors, and $3,000 for the fourth count, violation of 4.18 illegal conduct.
Mr. Chairman, it's also my understanding, I've had a chance to review that with my clients, that is agreeable to them.
It is.
It is, that's correct.
There will be no testimony then.
No, there'll be no testimony in the facts of the case, Your Honor. And preliminarily, Your Honor, I'd like to move as Liquor Board's Exhibit Number 1 collectively, the evidence file which I have placed in the file.
All right, any objection?
No objection, Your Honor.
And all the
Mark it.
and all the exhibits have been marked, pre-marked.
Go ahead, sir.
Thank you, Your Honor. On October 24, 2014, approximately 11:30 p.m., Sergeant Morales of the Baltimore City Police Department was actually standing to my left, conducted an underage drinking investigation at the location Max's Pizza Bar and Grill located at 3003 North Charles Street. Accompanying him was Captain Caphammer. Oh, sorry. Captain Caphammer, who's also Major Caphammer. I'm sorry, I apologize. Major Caphammer is standing to my left, and also Officer Joe Jefferson, who is not present now. Police entered the location, and Sergeant Morales was confronted by a shoulder-to-shoulder crowd of people. Upon entering the bar, a police officer observed a young-looking male drinking a 12-ounce bottle of Corona Extra. The police officer asked how old the man was, and he responded 18. The young man produced an ID that confirmed his age. The young man also told the police officer that he was given a blue wristband that allowed him to purchase alcohol after he showed his identification, which indicated he was 18 years old, to the assistant manager. It was the assistant manager who gave the wristband to the young man. As the police officer was conducting his investigation, another police officer is actually present. Last name, officer? Officer Edick, who's present today, overheard a bar employee telling patrons to hide in the restrooms to avoid police. Is that correct, officer? On November 20th, 2014, approximately 9:47 p.m., the Baltimore City Vice Squad conducted an investigation into underage drinking at the location of Max's Pizza Bar and Grill located at 3003 North Charles Street. Vice Squad was working with an undercover cadet. Cadet, is it Nesser? Nizer, I'm sorry, Cadet Nizer. And Cadet Nizer, if you could you please tell the board your age and your birth date?
We need to have her sworn.
So I apologize.
Everybody raise your right hand, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
You can. Cadet Nizer, if you could please relate, actually Cadet, if you could please tell your age, current age, and date of birth.
My current age is 20, my date of birth is 6/2/94.
Okay. And on that date, Cadet Nizer entered the location, the Max's Bar and Grill, approximately 9:47 p.m. and sat at the bar. She ordered a Coors Light bottle and paid $4 for it. This time, the bartender served her without carding her. She then communicated with the Vice Squad, who's present here today in court, Detectives Gatto over there, Detective Greenhill, and Sergeant Leisher all the way in the back. And they entered the premises and confirmed that she was served an alcoholic beverage. The Vice Squad returned the $4 and informed the bartender of the infraction. All events occurred in Baltimore City, Your Honor. That would be the Liquor Board's case.
No additions, deletions, corrections, or modifications, Your Honor.
All right. Anything, any questions? Any questions?
No questions.
All right, questions of commissioners?
None.
Just wonder, who is the assistant manager for Max's?
Actually, I have to just pull the case file, Your Honor. I have listed here, bear with me, Your Honor. Bear with me, Madam Commissioner, I apologize. I have a John Andrew Leducas, who was serving the patron, and I'm just checking for the, Non-Mi Sean was identified as the assistant manager, and it's actually in one of the exhibits, but I have a copy of it right here. I'm just putting my finger, if I may, present this to you, Madam Commissioner. You see where my finger is right there?
So, we've got evidence for October 24, 2014, and November 20, 2014, two separate.
Correct, Your Honor. And in the charges, they're listed that way. Charge number 3, violation 4.01, minors, lists that the incident occurred on November 20th, 2014.
That's right.
Okay.
All right, folks, we're ready for a decision in this case.
No testimony?
Pardon?
No testimony?
No, it's a plea.
Oh, I see.
They've acknowledged the facts. But I'd be glad to hear from you always.
I'd be interested to hear what you have to say.
I would appreciate the chance.
Come on up. Always glad to see you.
Right.
I'm Mary Pat.
Nice to meet you, Councilwoman.
Nice to meet you.
Would you like to know what the agreement was?
I heard it. Oh, I heard what it was said, 6 weeks, $8,000.
Correct.
I'm more interested in the weeks than the money, actually. I have letters here. I didn't realize there was going to be a plea agreement. I can summarize what I've said, but you have your copy, right?
That's right.
Yeah. If I could. One from Michelle. Okay. My name is Mary Pat Clark. I'm the City Council representative in this area. I came here today to recommend that this establishment be closed for the duration of this school year, and that would take it to June 1st of 2015. I don't have a penalty that I'm recommending, a financial one. It's sort of irrelevant to me. The time is much more important. And that the condition of resuming operations on June 1 would be that the licensees would enter into a memorandum of understanding with the Charles Village Association about, and would voluntarily agree to amend their liquor license to reflect some of the conditions that they negotiate and agree to. Now, the reason that I was recommending such a long period of closure is to get us through this school year. This is one of the, I know that this is one of the two establishments that Loyola College is the most concerned about in terms of its students. The other one's not in my district. Also, the neighbors have complained to me a lot. Now, Maxey's is not in a residential block, but it backs up to the 2900 block of St. Paul Street, where there are already 3 fraternity houses. And what their complaint is that at closure, and these are on weekends mainly, there are herds of young people, a lot of them loud and presumably inebriated, that come onto St. Paul Street to hail cabs and cars, theoretically, who knows, to go downtown to after-hours clubs, who knows? They need to go, they're going south. And so that's where the bunch of them goes. Now, this place has such a reputation for serving minors, even when they show that the card that says I'm 18, that I just think we need to just close it and start again with a new class of kids coming in after the summer. And that's why I made that recommendation. So I'd rather trade in the $8,000 for extra weeks so that they could get themselves together, negotiate with Charles Village, get a memorandum of understanding, prepare themselves to sort of resurrect themselves as a good venue that, and I don't care if they keep serving pizzas while while the license is closed, but I don't want them serving liquor, and I don't want them having hours where these undergraduate kids are still going to come, because why wouldn't they? They're used to it.
Well, let me, as usual, speak in response to your well-reasoned and certainly persuasive remarks that you always have. When I came before the board as chairman, I came to a situation which I don't want to be critical, but it seemed to somewhat permissive, in the sense that the word was that you would get a fine, but not a closure. And so what I did right from the beginning, with the permission of my two commissioners, who we all stuck together as a group, we began to close bars.
Right.
And what we were telling them at that time was, we want you to take this as a warning. We're not going to put you out of business because you've been getting away with it, and we're not going to suddenly drop the whole ceiling on you. We're going to give you a warning, and we're also going to try to reorganize our inspection staff, and bring in new personnel, and some new attitudes, and some people like the man right behind you who've done a very good prosecutorial type of position. And then we follow up. And when we find that the warning hasn't worked, then you come back for maybe, I'm not going to prejudge a case, but perhaps a more serious result. And that is what we've had here, in a sense, because we've had one prior case involving Loyola in which we closed it for 1 month, in which the facts were somewhat similar to this case. The oldest person in the bar that we closed for 1 month was 19, and there were lots of them.
And he was the bartender.
Maybe. But like this case, where there's a record, where it wasn't mentioned, but there is a record here, where there's been prior problems. In 2012, 2 of them, minor and minor, in both cases of the 2 records, took that into consideration in this case as well as the other case. And we also have cases, another case, you said 1, I know of maybe 2 coming up, of similar types with similar school, Loyola, although this is in the center of the Hopkins campus, this location right here.
You mean the one we're talking about?
The one we're talking about today.
Well, I'm not saying the Hopkins students don't go there too, but.
Well, in this particular case, it happened to be all Loyola that were identified. And I understand the basement was full of children too. I call them children when you get to be my age.
Youngsters.
Youngsters?
I said that in my letter.
Okay, I'll adopt your word.
And we have a responsibility to keep them safe, and they're not.
Actually, this sentence is really a month, because school doesn't go back into session until the 23rd of January. So they really are not giving up any students between now and the 23rd of January. And then, of course, another month.
That's what I know.
Another month after that. So what we're really doing is giving them somewhat similar punishment that we've already alerted other bars. And we're sending out the word. And these officers here know that this board listens carefully to the testimony that they bring in And we're making sure that the community understands that these officers are not wasting their time going in and out of these places and bringing the charges before this commission. Because this commission's been very serious about closing bars, and we've been closing a lot of them. And I hope you speak to some of the judges of the Circuit Court of Baltimore City who have been reopening some of the bars that we have closed. Trying to get the word up there that the law is that what we do here is presumed correct at the Circuit Court level. That's the law passed by the Maryland General Assembly. So I know I probably haven't satisfied you in my response, but I want to give you my philosophy.
Right, and I appreciate it, and I know how well this board has acted on behalf of people all over the city. I'm very worried about the continued operation of this, and we have no agreement, we have no formalized agreement with the community, which I think would be very helpful, that could be voluntarily added as the conditions on the license itself. And I came here today expecting just a hearing, and I understand that what you've got is a plea, which is a whole different can of worms. In other words, it preempts.
Doesn't preempt anything, because we don't have to accept the plea, but in this particular case,
I
have
understand.
talked to everybody without having any opinion of my own, and they thought, in view of the past of what we've done, and in view of this sentence in this particular case, which has been agreed to, and the closure of the bar, and I don't have to say it again, I hate saying things twice,
I'm sorry.
the future will tell what will happen with respect to your desires, because if it comes back, well then, you know, I'm
Well,
not gonna
what about a
prejudge it.
memorandum of agreement, at least with the community? I mean, you've got 6 weeks, right?
Yes.
I haven't had a chance to even talk to them about it. Oh, there she is.
I can speak to that.
Be glad to hear from you.
Thank you.
This is a plea, we don't have to be sworn.
Sandy Sparks, President of the Charles Village Civic Association, and I apologize for being late. We are prepared to create an MOU with Maxey's.
You're prepared, or they prepared too?
Well, we are. We would like to see that happen, and this is the letter that I wrote proposing that idea. And we have been very successful with other MOUs, with other liquor establishments in the area, and we feel that this would be a good remedy.
Well, of course, there is no MOU before us that's been agreed to at this time, so I can't bring it in and make it a part of the case.
Really?
No. Not been agreed to.
voluntarily agreed that they would do that
Oh, well, that would make it a part of the case.
well, then, I would like to, how do I ask them if they would voluntarily
Ask the
agree to
attorney
enter
right
into
here.
one before their suspension is over?
Go ahead.
Mr. Chairman,
Yeah.
you know, from my understanding of the live testimony, I understand community.
Well, wait a minute, we didn't understand anything before we came here.
Wait, one person at a time.
Oh,
If I
sorry.
may finish. We were under the impression, I believe rightfully so, that the plea was what it was. I haven't had a chance to discuss these additional requirements just being brought up today with my clients. I will tell the board that I always think it is a good idea to speak with the community. It usually helps relations in the future should there be any problems. It usually helps to alleviate most problems with the community. Again, I have not discussed that as a condition of the plea agreement that was agreed to before we came in today. I have to do so with my clients at a later time, but I will say in all candor with your honor and board, I will encourage them to do so as I do with all of my clients who hold licenses.
There you are,
So the answer is no, at the moment.
at the moment. Yeah.
So we'll be back.
Maybe they'll, everything will be,
Yeah, we'll be back.
Hopefully not.
We'll be back in April.
I'm hopeful.
all right, folks, now, anything else from the commissioners?
I have a question. The gentleman out here in the blue shirt, what is are you affiliated with Maxey's?
He's my client's wife, husband, I'm sorry. It's his husband.
Okay, does he work at Maxey's at all?
To the extent that he's, again, my client's husband, he does come by once in a while. He owns a restaurant in the Horseshoe Casino. That's where his main place of business is.
Okay, okay. Well, I guess this is more of a comment. I understand there's essentially a plea agreement, and it imposes, I think, serious penalties. But I would encourage your clients to work out an agreement with the Charlesville Civic Association and any other association that has an interest. There is a plea agreement, but that does not take away from the seriousness of what happened here. I have to say it, that the most egregious act to me was the effort to push students into the bathrooms so that they would not be discovered. I don't understand that from a legitimate business that purportedly operates within the law. That was highly concerning. There are other aspects of this case that are extremely concerning. The impact on the community is not small, and it's not just Charles Village. It carries over to the communities surrounding Loyola, because apparently that's where the students go back to. There's a lot of members of the police force that are here today, all prepared to testify. We have city council persons on both sides, purportedly, prepared to testify. It's not a small matter. It has had a huge impact on our community, and it's not a small thing. This license is going to be up for renewal, I guess, in May.
Yes.
And at that time, there could be protests in April. And so it would behoove your clients to resolve as much of the concerns and quiet the concerns, and then operate within the law going forward. I don't want to take the words out of Judge Ward's mouth, but a license is a privilege, not a right. And so, I mean, it's just so clear that you are so close, your clients are so close to losing that right, or that privilege.
Thank you.
Yeah.
Yes,
So-
all liquor licenses come up for renewal in April.
This is one that, someone asked me, do we actually follow up? And we have basically pre-hearing conferences before we come out, and it's not, we don't make any decisions, but we make sure that the staff are actually following up and keeping track of what is supposed to happen. And if fines are imposed, that those fines are collected, that whatever penalties are actually being paid. If we have questions, we want answers. So this case, there is an agreement, and I think that's great, but it doesn't mean that attention will no longer be paid. Attention will continue to be paid to Maxey's.
Councilwoman Clark, I'd like to tell you that I think that our staff is stronger since
I think you're doing a great job.
I think you came, and we also appreciate the support we've been getting from the city of Baltimore. Instead of being told who to hire and so forth, we've been left alone, and we've been putting first-class people, we think, on deck. And I think that you're going to find that the word is out among the licensees of the city, that a warning is a warning, and if you come back, who knows? And we appreciate your support. And
I would just ask that the next time that there is a, what do you call this, a consent decree or
A plea.
a plea?
Well, this is not a criminal court, of
Yes,
course. This is
No,
a civil court.
I know.
And it's a community board, and so I
Please.
really steer away from guilty and all that sort of thing.
Right. What all I was saying is, this was a done deal before we walked in, not
Yes.
because we didn't know about it. I'm the council representative, and this is the president of the local neighborhood association. So,
That's true.
and what we don't, so we didn't know when we came, and we were, basically, it was done. We would ask that that not happen again. If everybody's gonna be talked to, then the community should be included.
Absolutely.
Second,
The way these things sometimes happen is when we have dockets, the council, for whoever is being charged,
yes,
comes with a suggestion. In this particular case, the suggestion was not acceptable to the commission. and so it was discussed by staff, not by us, and then by us. And we asked if everybody had been talked to, and we were told they had been.
Well, they had.
And,
So
and
we
yes,
need
we
to
accept your word.
correct the way people are talked to and who they are.
But I'm not unhappy. I want to tell you that I'm not unhappy with what we're doing. I think it's a correct decision.
I know you do. You wouldn't do it if you didn't think so.
That's absolutely
I have a lot of
correct.
respect for you personally and for this board. But I just wanted to make that point. In the future, we would like to be included and not come into something that's a done deal. Secondly, the other thing is,
I think you have been every time you've been before me.
yes, I mean, I've always been treated very well. The other thing is, we have no idea of what this licensee is going to do to fix things. And there's no room in this hearing for that to be discussed. And
Well,
so
but
we
that's-
don't know what,
But that's not true, because you see, we have an inspector staff, and we have all kinds of people, including the police department, that's gonna be watching, not
well,
only
the
this
police
one.
department, we would like the police department to be watching our neighborhood,
That's true too.
not our bars. And look at all these offices, look at them. I mean, this is about a shift. That's like the equivalent of one shift, almost. Maybe add 3? Oh, there they are. You got the equivalent of one shift of Northern District Police officers spending their time in a bar instead of in our neighborhoods, which is ridiculous. So basically, I know, so we don't know what they're gonna do here to change anything. Are they gonna get new managers? Is the licensee gonna be there all the time? We have no idea. We have somebody that thinks it would be nice to talk to the neighborhood, but we don't have any kind of a requirement until we come and file in March against the continuation of this license. And one of the reasons will be a public refusal to enter into a voluntary memorandum of understanding. So all I'm saying is I'm asking you and this board and the staff to remember in every case, when there's some kind of plea, the community that's been impacted should be involved in being talked to about it. Thanks.
All right, ready for decision. Decision is that the bar shall be closed immediately, commencing today, for 6 weeks. And at the end of 6 weeks, it'd be, of course, back into service again. But however, subjected to the fines, and I'm looking for the, here it is, with respect to Rule 3.02, $3,000 fine. With respect to Rule 4.01A, minors, $1,000 fine. With respect to Rule 4.01A, minors, $1,000 fine. For violation of Rule 4.18, illegal conduct, $3,000, plus the usual administrative costs. You understand the decision, sir?
I do, Your Honor.
All right, then let it be enrolled.
Thank you. May be excused.
Thanks for everybody for coming. And all these exhibits, please place them in the file. Exhibit.
Can I call the next case?
Not
Yes.
yet, no, not yet.
Wait a
He's
minute.
gonna get the husband is actually the bar manager. Yes, I mean, that's who I saw who was stocking up the bar when they first opened, is the woman's husband.
Folks, what did we do last time on that, no, the case of the closure where there was,
All the students.
you know, when you go from 1 hour to 2 hours, and all that stuff changes time. Daylight savings.
Just
time.
last-
Daylight savings time. The last time you did a weekend closure because they had a previous violation. You did a weekend on them, 3 days.
4 days. Was that
Yeah, it was 3 days. It was 3 days. But they actually had a previous violation. I mean, this one doesn't. So,
You okay with it.
Okay.
I mean, you okay with it, I guess?
Yes,
You
yeah.
okay?
He's counsel. May I call the next case?
Check with him.
Call the
See.
case.
Wait, almost, oh, he's almost ready. Okay.
Yes?
ready.
Okay.
You okay? Call.
Okay. Baltimore City Liquor Board versus L. Estanco LLC, Alexandria Abreu, and Maria Hernandez, trading as L. Estanco. Thomas Akris on behalf of the Liquor Board, and with me is Lieutenant Colburn.
All right, swear the witnesses.
Raise your right hands, please. Raise your right hand. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth? I do.
You got to hear from him, Mr. Harris?
Your Honor, first I'm going to make a preliminary motion. I'm going to enter into evidence the evidence folder that has accompanied this particular case file. It includes a copy of the police report and a copy of daylight savings time, and I've provided those copies to defense counsel prior to the hearing, Your Honor.
Market Exhibit 1, go ahead.
Also, preliminarily, I'd like to ask the court to take judicial notice, the hearing board to take judicial notice of the fact that daylight savings time was switching over on the date in question, November 2nd, 2014.
Any objection?
No objection.
And your name, sir?
Paul Schumann.
And you are the counsel,
Yes, sir.
okay? Mark it,
Uh,
or admit it.
Your Honor, on November 2nd, 2014, approximately 2:11 a.m., Lieutenant Colburn of the Baltimore City Police Department, standing to my left, was called to the location of El Estanco, located at 45 North Crescent Street. He was originally called there because there was a call for loud noise on the even block of North Crescent Street. But based on his observations,
Well, there's no plea in this case, you have to call your witness.
Okay. I was just reciting the facts, Your Honor.
I know, but there's no plea.
Court indulgence. Are we going forward today on the plea? Yeah, Your Honor, I apologize, strike that. We were going to go forward on a statement of facts. Defense counsel
Well,
was,
let me find out if that's true. Is it,
That's correct.
on behalf of your client, you're willing to accept a statement of facts as the facts in this case without live testimony,
That is correct.
all right? I find that he voluntarily has submitted himself to the hearing board in that respect, and I'll be glad to hear from you with respect to the facts.
thank you, Your Honor. Again, on November 2nd, 2014, approximately 2:11 a.m., Lieutenant Colburn of Baltimore City Police Department, standing to my left, was called to the location of El Estanco, located at 45 North Crescent Street. Lieutenant Colburn was responding to a call for a bar being opened after hours and for loud music. As the lieutenant approached El Estanco, he could hear loud music and voices coming from the bar. The bar only has a license to operate until 1 a.m. Police officer observed through a window multiple consumed bottles of Corona on the tables within the establishment. After knocking numerous times on the door, police officer was able to gain entry. Once inside, the police officer observed approximately 17 persons still at the bar. Upon entering into the establishment, all the bottles of beer were cleared off the table. At that time, the managers on site stated that the people in the bar were patrons. At that time, the patrons were cleared from the establishment and the bar was closed. Your Honor, all events occurred in Baltimore City, state of Maryland. That will be Liquor Board's case, and I'll just note that there have been no past violations for this particular establishment.
Only a couple, sir. First, I spoke to managers. They said that they could not speak English. They never said they were patrons. In fact, the people in there were family members. They have a large family, and they were cleaning up. Also, and this may have been simply incorrect in the police report, but it says they were originally called to 40 North Crescent Street, not 45. No other modifications.
All right, I noted from that your summation of the facts on behalf of the bringing the charges, that there were 17 people in the bar at the time that the police officers were able to enter.
Mm-hmm.
You telling me that all 17 were members of the family?
Yes, Your Honor. Yes, Your Honor. Yes. That's what I was told.
All right, and there's no record in this case?
No past violations, Your Honor.
All right, now with respect to responsibility for the charges which have been admitted, does the commissioners have any, not as to punishment, but does the commissioners have any questions?
Not a question, but a comment, two comments. One, you need to come a little forward as counsel, and you can have your client come forward just so that we don't have any trouble hearing you. And just a comment, it doesn't matter to me, whether they're family members or not family members, if they're in the bar and it's after hours, they're consuming alcohol, that's the case. The fact that they're family members does not take away from me responsibilities. I just want to say that.
Can I just, may I respond briefly?
Certainly.
I was told that they were there and they were actually cleaning up, and at the time the officers responded, the doors were locked and there was no public access to the bar.
They could see through the window. That's the issue. I mean, they observed through the window that there were open bottles of beer, and there was some amount of time that passed before the door was open, and when the door was open, the beer bottles were gone. So that to me says that they knew that there was a problem.
Well, let me say this to you, counsel, that when, first of all, there's an admission in this case, but over and above that, when you're running an alcoholic establishment and you've reached the time when you're supposed to close, first of all, the loud music should be turned off. You should be operating in a condition of down, off, over. Instead, this loud music, according to the facts, was going on, and there are 17 people in there, and there are bottles on the bar and so forth, and they were cleared off after the police were able to get in. In other words, there's an atmosphere of operation in this case. And I find that there's more than sufficient evidence in this case to prove the facts that your client has been charged with.
One comment.
Yes, go ahead, sir.
If you come before this board again, and you're going to defend your client by saying that the occupants in the establishment were working, bring some records with you. If you bring records showing that they are employed by that establishment, then maybe we might consider the information you present to us.
Yes,
But
sir.
without records, they don't work there.
Yes, sir.
All right, punishment. Now, with respect to punishment. Sir, do you have anything you wish to say on what we should do with respect to punishment?
I have some documents.
The word punishment is not the correct word, but what our decision should be.
First of all, I have articles of revival because at the time their charge was forfeit.
That's
They
good.
brought all that current. I've already showed this
Yes.
to council. so
That's
I have
correct.
these. I also have two alcohol awareness certificates which were completed. And I also have 2 letters of recommendation from the community. And I've shown these all to prison council.
Okay,
Yes.
so give it to us so we can
No
see.
objection.
I'm going to give it to him first.
Okay, that's fine.
This letter here is from whom?
Was it? This is his last name.
Hey, gotcha. You gotta mark it. Collectively, all of these are. These are the two, it's that.
Jose Alasso.
And who is it? Is it a neighbor or what?
Who's talking?
He is on the front line, is he coming in the
Is he in El Barrio? He lives in the neighborhood, Your Honor. He's,
Okay. And it's a recommendation.
yes, correct. Yes, Your Honor. And Your Honor, I spoke with Lieutenant Colburn, and he informed me that the patrons were not, or not the patrons, the managers weren't uncooperative.
Uncooperative.
Were not uncooperative.
We're not uncooperative.
Correct.
All right. All right, commissioners, questions or recommendations with respect to punishment? If the word is it correct?
Penalty, what the penalty should be.
Penalty, yeah, better word.
We have a similar case, and we try to be consistent with how we, I guess, deliver punishment, if you want to call it that, but I would call resolved cases. I think we gave 3 days suspension. In the last case we had similar to this one, and that would be my recommendation, 3 days suspension. whatever fine we conclude, we agree to.
As well.
And a fine also.
So I would do a fine and maybe 1 day suspension, and here's why. I think the last case, they had some prior violation. And so, Mr. Akers,
Yeah.
what is your thought?
Your Honor, and Your Honors, I was under the impression because this, and I'll, be candid, I had spoken with defense counsel, and what I said was, if you go forward, it's likely that it will be just a fine, but I can't speak for the board, and the board can make any decision that it wants to, and I'm just clear about that. I wasn't speaking for the board, and I never said I was speaking for the board, correct?
That's absolutely correct.
I said it's likely that it could be a fine, but they could suspend you as well, and I made that very clear, correct?
You did, yes.
All right, with respect to decision, I noted from my facts that you have introduced into evidence as a part of Exhibit 1, that actually the place was still open for 2 hours and 11 minutes after the daylight saving change had occurred. And while there's no prior record in this case, it seems to me there were 17 people in the bar, and the testimony of the police officers through reports that all have been admitted into evidence, that this is a blatant violation of the closing time. And I agree with Ms. Clark, who in the last case, that the police department's job is not to be running these bars in the city. And what we have to do as a board is to let people know that they're supposed to do what they're supposed to do. Therefore, I say three days suspension starting now, and the fine of $500. That's my decision.
I concur.
I feel it should be 1 day, $500 fine.
All right, you have our decision, sir. 3 days suspension, $500 fine. You go down with the clerk. How much time do you need to pay the fine?
How much time do you need to pay?
Yeah, very cash.
How much time do you need? Can you pay it now?
500.
Efectivo?
Sí.
No.
No
En
cash.
tarjeta.
Plus the
No,
cost.
no tarjeta de crédito, pero
Un cheque.
Plus the cost.
how much are costs?
$125.
$625. Got it. Okay, all right.
So what?
It's $625, correct?
How much time?
How much time do you require? ¿Cuántos días? 7. ¿Tú tienes efectivo ahora?
Sí, yo tengo.
Pero tú, court's indulgence.
Yes.
Una
Tú puedes
semana.
obtener un cheque, un money order, en
Sí, tengo el cheque, pero hay que, tengo que.
check personal.
Sí,
All right.
A
Do you take money order?
cashier's check or money order.
porque yo tengo cash.
No, pero un money order.
Y tarjeta.
Tú tienes que obtener un money order.
We'll just do
¿Tú sabes?
14 days.
Let's give her a week.
Whatever we.
Let's give her a week.
Just
Tú
give
tienes
it a
una
week.
semana a pagar este. Okay?
We're off the record. Pero tengo que venir aquí o a dónde?
You can come to the office. Tú puedes venir a la oficina
Aquí
del
abajo.
liquor board. O tú puedes, you can give it to your attorney.
Judge, do you
Tú
need to
puedes
see how
darte
I
tu
can do
attorney.
this?
Okay.
No.
I'll speak with the attorney. I'll work with the attorney. She'll have a week.
1 week, all right, that's all we need on the record. She wants 1 week, and 1 week it is. That's okay with you, Commissioner?
Yes.
Okay, all right. All right, thank you, that's a decision.
Thank you, Your Honor.
Thank you, take care.
Okay, thank you.
And we're in recess until next week.
So that one was postponed, that's the last one.
That's our last case.
I have.
Ay, ay, ay.